first case. It's Computer Associates versus Altai. Came out of the Second Circuit. The case was originally filed in federal court in New York. The case is well cited for the proposition that in order to determine whether there is copyright protection based on non-literal elements of the code, courts apply the abstraction, filtration, and comparison test. Now, let me see if I can go through the facts, and I can give you some elaboration on the test. Computer Associates had a program. It was I believe it was the adopter. Altai had started to market its own code. Altai had a computer code, a computer program, which was its 3.4 system. Now, the 3.4 system of Altai copied about 30% of the Computer Associates code. Computer Associates sued for copyright infringement in federal court in New York around 1991. Then, as soon as Altai was sued, they engaged in a crash project. They redesigned it and came out with their 3.5 version. Now, 3.5 did not copy any lines of code from the Computer Associates code. However, it did have what Computer Associates referred to as the same. Now, by the way, I've been referring to copying of code, and I think all of you know by now what copying of code is like. I noticed from your outline that there is a reference that thou shalt not copy thy fellow classmates' code. There could be severe ethical implications. And by the way, in case you don't know it, you can also be sued for copyright infringement. So you want to be very careful about copying anyone's code. Anyway, though, that, by the way, also goes for code that's not published. So here comes Computer Associates. They're suing Altai for infringement based on Altai's 3.4 and 3.5. Case comes up in federal court in New York, and the trial court applied the test of abstraction, filtration, and comparison in order to determine whether or not there was copyright infringement of the Computer Associates code. Now, the concept seems to be somewhat I thought it was somewhat nebulous. The abstraction requirement requires that in a manner that resembles reverse engineering on a theoretical basis, the court should dissect the copied program structure and isolate each level of abstraction. Now, when I read this from the opinion, I wondered, how am I going to explain this to Dr. Leitner's class? But then I saw your course outline in page 6. I know you all read the course outline. In the section involving models and abstractions of computing, Dr. Leitner says, one of the ways a computer scientist manages the complexity of large systems is to regard them as implementations of formal mathematical abstractions. Some of the models that are useful are so commonly employed so as to be part of the vocabulary of every professional computer scientist. Now, it's fortunate that my talk comes at the end of the semester, so by this time you know all of the parts of the vocabulary of every professional computer scientist. So when the court was referring to all of these elements, I assumed that they were referring to all of these things that you have now become familiar with. So the court said that it first has to isolate all of these elements and then filter out the non-protectable elements. Recall in Sega versus Accolade that you cannot have any protection on utilitarian features. Well, in the opinion, the court enumerated a number of the elements that are not protectable based on concepts like elements dictated by efficiency, elements dictated by external factors such as mathematical specs, compatibility with other programs, demands of the industry, elements taken from the public domain, and commonplace elements. So then the court filters out all of those things and then compares what's left over with the defendant's computer program to determine what is protectable and what's not protectable. So that's the abstraction, filtration, comparison test. At trial, takes a lot of experts. It could be kind of not very interesting, almost boring, except for computer scientists. They kind of like that kind of testimony. After applying the test, the trial judge determined, I mean, it was kind of easy when it came to Alti's 3.4. They copied 30% of the code. And so the trial rendered a verdict for Computer Associates based on Alti's 3.4. But when it came to 3.5, that just had the same structure. And on that basis, the judge rendered a verdict for Alti. Now, in fact, the trial judge gave Computer Associates about $364,000 based on Alti's having copied in its 3.4. Well, it's rather interesting that the case went on appeal. The Court of Appeal looked at both of these at first, and then Alti dropped its appeal based on the 3.4. It did something that was kind of strategically pretty smart. It effectively said to the judge, the Court of Appeals, the three-panel judges, we know we're liable for infringement based on 3.4. We'll pay the $364,000. But on 3.5, that's where there's no liability for copyright infringement. And in fact, the Court of Appeals, it was probably a strategical decision because the Court of Appeals agreed with Alti. Based on 3.5, there was no copyright infringement because the only thing that was copied was the structure, not necessarily any lines of code. And structure was considered non-protectable. So Computer Associates could say that they won the case based on the $364,000. I don't know how much the value of 3.5 was worth. But anyway, though, Alti then went ahead and presumably continued to market 3.5. That case was decided by the Second Circuit Court of Appeals sometime around 1992. And let's just look at one more case involving non-literal elements of code. And that's, this one is a menu hierarchy case. I think that one of you has helped me put the menu hierarchy up. This was the Lotus versus Borland. Now, I call this the copyright computer program lawyers pay off the second and buy a luxury car case. This case started here in Boston around 1990, went up around, I think the final decision was around 1996. It started when Lotus sued paperback software. Lotus had this Lotus 123 spreadsheet, which was a pretty valuable spreadsheet. I think that it used to be used quite a bit. And it alleged that others were copying its spreadsheet. And in fact, it got a judgment against paperback software. Paperback didn't appeal. Maybe it just didn't have the finances. That's not an uncommon situation. Anyway, though, then about 3 days later, it sued Borland here in federal court in Boston. Now, the trial judge broke up the case into almost 4 different segments and 4 different types of case, 4 different issues. And in each issue, the trial judge addressed one of the different issues. And after it was all over, after the entire trial was over, the trial judge rendered a decision for Lotus. Now, this was based, as you can see, on the Lotus 123 menu. I have the menu hierarchy here, and that was one of the points of contention in the case. That is, Borland was using the menu hierarchy, but it didn't copy any of the lines of code. It did this so as to make its software compatible with the Lotus 123.